Module 12, Employment Protections for Survivors of Violence. In this portion of the training, we will discuss employment issues commonly faced by survivors. We will also discuss the legal protections available to address these employment issues. The objectives are to understand the effects of domestic violence, sexual assault, and stalking on a survivor's employment, to understand the legal protections available to survivors which enable them to maintain their employment and economic security, and to understand the role of an advocate in helping a survivor request accommodation, leaves of absence, and other employment-related protections. In this lesson, a copy of A Survivor's Toolkit for Employment Rights in California is provided. This toolkit includes information on much of what will be discussed during this lesson, as well as sample letters and forms that you can use as an advocate to share with a survivor. Workplace implications of domestic violence, sexual assault, and stalking. It is important to understand how economic security and financial stability is impacted by violence and how crucial it is for survivors to maintain their employment. The economic security that comes with steady employment is essential to a survivor's ability to escape abuse and take measures to keep herself and her family safe, yet that security is often at risk. According to a 2011 study commissioned by Legal Aid Society Employment Law Center's Project Survive, 71% of survivors surveyed reported being employed while experiencing domestic violence. Of those, nearly 40% reported either being terminated or fearing termination related to the violence. Think about whether you have ever worked with survivors who have had employment problems, and in what ways do you believe domestic violence, sexual assault, and stalking could affect a survivor's employment. It is important to know what the service provider's role in securing workplace protections for survivors is. This role includes identifying a survivor's employment-related needs, certifying a survivor's needs for workplace entitlement, and providing referrals for legal advice or representation. Workplace implications of domestic violence and sexual assault. Fortunately, there are legal protections that address many of these needs. It is important that you and the survivors you serve are aware of their legal rights and how those rights can protect their employment when they need time off or other workplace changes because of domestic violence, sexual assault, or stalking. Some examples include the following. A survivor may need time off work to heal from injuries or to care for a child who experienced or witnessed violence. A survivor may need to flee to a shelter and be unable to work temporarily or may need to permanently relocate. A survivor may need a restraining order or protection from harassment while at work. A survivor may need a reasonable, safety-related accommodation at their workplace. A survivor may need protection against someone discriminating against them because they are a survivor. Or a survivor may need accommodations on the job due to a disability caused or aggravated by violence. California law, leave rights for survivors. Labor Code Section 230 allows job-protected time off to go to court, and Labor Code Section 230.1 allows job-protected time off for services including doctor or counseling visits, temporary or permanent relocation such as shelter stay, safety planning, meeting with the sexual assault and/or DV advocate, prohibits retaliation for taking leave to seek services. California law allows survivors to take job-protected time off from work to obtain assistance from a court to ensure their own health, safety of welfare, or that of their child. This assistance may include a restraining order or other injunctive relief such as child support, child custody, or divorce court hearings. This protection applies to survivors working at any company or organization in California, regardless of the number of employees. Survivors who work for an employer with at least 25 employees are entitled to take job-protected time off to obtain other services, such as attending medical or counseling appointments, relocating, or safety planning. The Labor Code provisions specific to survivors of domestic violence and sexual assault were amended as of January 2014 by Senate Bill 400. Now, the Labor Code also protects victims of stalking, entitles survivors to reasonable safety-related accommodations, and prohibits employers from discriminating against employees because of their survivor status or retaliating against survivors who ask for workplace accommodations. In order for termination or other negative employment actions to be unlawful under SB 400, an employer must have knowledge that someone is a survivor of domestic violence, sexual assault, or stalking, and they must discriminate against them because they are a survivor. The following are some examples. Annie advises her supervisor that she is in the process of getting her name changed as a part of a safety plan to protect her from her ex-husband. Her employer then tells her that she is a liability and fires her. Maria tells her employer that she fears her ex-boyfriend and has a restraining order against him. Her employer tells her that it does not want to become involved in her personal problems and fires her. Laura advises her employer that her stalker has been calling her multiple times each day on her work line. Her boss terminates her for taking too many personal calls. As I read Kate's story, think about if the employer's actions are unlawful. When Kate informed her supervisor that her husband had threatened to hurt her, her employer told her to take time off to seek counseling. At her employer's request, Kate testified in support of a workplace restraining order, which was granted. But when Kate tried to go back to work, her employer refused to reinstate her and forced her to either resign or be fired, citing safety concerns. Since Kate's employer terminated her because she was a survivor of domestic violence, the termination is unlawful under the California Labor Code as amended by SB 400. Reasonable accommodations under SB 400. California law entitles survivors to reasonable safety-related accommodations at the workplace. When a survivor requests a reasonable safety accommodation at work related to domestic violence, sexual assault, or stalking, the law requires her employer to talk with her about her needs so that together they can determine what accommodation addresses the survivor's safety concerns and is also feasible for an employer. Employers are not required to provide an accommodation that would be unduly expensive or disruptive to the business, but if they deny a requested accommodation for that reason, they should consider and discuss alternative options with the survivor. Accommodations might be safety-related accommodations, individualized based on particular needs of the employee. Employers should participate in an interactive process with the employee to determine effective accommodations, and it cannot cause an undue hardship to the business. This is a list of several common, reasonable safety-related accommodations: changing work telephone extensions, removing contact information from websites, relocating a workstation, modifying schedules, reassigning to a different shift, allowing a transfer to a different location, installing locks, surveillance cameras, or other equipment to enhance the security of the workplace, assisting a survivor in documenting violence that occurs in the workplace, and referring a survivor to a victim assistance program. However, there is no definitive list of what might constitute a reasonable safety-related accommodation. Instead, reasonable accommodations should be individualized according to the needs of the employee and the specifics of her job. Often, a survivor may know what sort of accommodation she needs at work to feel safe. At other times, she may not know, in which case a domestic violence or sexual assault counselor may be able to help her determine what type of accommodation or accommodations to request for her employer. In order to request a reasonable safety-related accommodation under the Labor Code, a survivor must disclose to her employer, typically either her manager, supervisor, or human resources, that she is a survivor of domestic violence, sexual assault, or stalking. However, an employer is legally prohibited from retaliating against a survivor because she requested an accommodation, nor may an employer discriminate against a survivor because she disclosed that she is a survivor. In response to a request for a leave of absence or reasonable safety-related accommodation under Labor Code 230 or 230.1, employers may request certification, which can be any of the following: a letter from a domestic violence or sexual assault counselor or a healthcare provider, a police report documenting the violence, or a court order such as a restraining order. An employer can request that a survivor provide a recertification every 6 months. Counselors can help survivors obtain accommodations or leaves of absence by providing written certification verifying that someone is a survivor of violence and requires the accommodation or leave that she is requesting. The Survivor's Toolkit includes sample certification letters that counselors can use to draft their own certification letters. As I read Carolina's story, think about what rights does Carolina have in this situation. When Carolina returned from a leave to recover from the effects of domestic violence, her boss moved her desk to the reception area in the front of the office. Fearing for her safety if her abusive ex-partner showed up at her workplace, she asked her employer to move her desk to a less exposed area in the back of the office. Her employer refused. In this example, Carolina would have the right to request a reasonable safety-related accommodation under the California Labor Code. You could provide her with a copy of the Survivor's Toolkit and point out the relevant sample request letters. And domestic violence and sexual assault counselors could also write a letter for Carolina, certifying both her status as a survivor of domestic violence and her need for a reasonable safety-related accommodation. Other employment protections available to survivors include the right to a safe workplace and freedom from a hostile workplace environment, job-protected leave to care for your own serious health condition or serious health condition of a family member, reasonable accommodation for disabilities related to the violence, and wage replacement while on leave from work or after having to quit a job to stay safe. Workplace safety. Employers' obligations under federal law. All employees are entitled to a safe workplace that is free of sex-based harassment. Employers have a duty to protect their workers from harassment, even if the source of the harassment is a third party. This is important for survivors with abusers who try to harass them at their workplace. In such instances, workplaces may take a number of actions to protect the survivor, including seeking a workplace restraining order against the abuser. As I read Pamela's story, think about what you would tell Pamela. Pamela's attacker obtains a job at her workplace. He routinely follows Pamela around and calls her bad names under his breath. He does this almost every day. Pamela is not sure anyone hears him, but there are loss prevention and security agents within earshot. Pamela has the right to a safe workplace free of sex-based harassment. It is important that Pamela's employer be made aware of the fact that she is being harassed by her coworker. To this end, you might advise Pamela to make a note of each incident of harassment, including the time, location, and what was said or done. Furthermore, it may be necessary for Pamela to inform her employer that the coworker has assaulted her previously and is continuing to harass her at work. Pamela would be entitled both to protection from sexual harassment and, as a survivor of sexual assault, she might also be entitled to a reasonable safety-related accommodation under the labor code, such as termination or transfer of her harasser. Employees who are eligible for leave under the Family Medical Leave Act or California's Family Rights Act are entitled up to 12 weeks per year of unpaid job-protected leave to tend to their own serious health condition or the serious health condition of a parent, child, spouse, or registered domestic partner. A serious health condition is an illness, injury, impairment, physical condition, or mental condition that causes a period of incapacity, meaning an inability to work, attend school, or perform other regular daily activities, and requires either an overnight stay in a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. This leave may also be taken to bond with a new child. To qualify for this type of leave, an employee must 1. Work for an employer who has at least 50 employees within a 75-mile radius of the worksite, 2. Have worked for that employer for at least 1 year, and 3. Have worked at least 1,250 hours in the year immediately preceding her need to leave. If a victim qualifies for job-protected leave for her own or a family member's serious health condition, a request for this leave does not require disclosure of the violence, but may require certification from a healthcare provider verifying that the victim or her family member has a serious health condition. However, because of California's strict privacy laws, the victim does not have to disclose the specific diagnosis. An employer should provide the victim with a certification form upon its request for certification. The survivor may also use the certification form included in the toolkit. Disability protections. The Americans with Disabilities Act and Fair Employment and Housing Act. This law prohibits discrimination against employees with mental or physical disabilities. Disabilities are impairments that substantially limit major life activities such as walking, sleeping, eating, breathing, thinking, learning, concentrating, interacting with others, and functions of bodily systems. And they may require a reasonable accommodation as well. Employees who do not qualify for a leave of absence under the FMLA Act or California Family Rights Act may qualify for a leave under the state or federal disability laws. If a survivor has a disability resulting from violence, such as post-traumatic stress disorder or another physical or mental disability, she may be entitled to a leave of absence as a reasonable accommodation under state or federal disability law as long as she works for an employer with at least 5 employees. This type of request does not require that the survivor tell their employer about the violence, but the employer can request medical documentation stating that she has a disability and needs a related accommodation. Reasonable accommodations other than leave may also be requested if needed to accommodate the disability of an employee. For instance, someone might request frequent breaks as a reasonable accommodation for panic attacks associated with an anxiety-related disability. While I read Lily's story, think about what you would tell Lily. Lily is a survivor of sexual assault. She has been diagnosed with PTSD. She needs to take time off for treatment and recovery. Lily returns to work, but is adjusting to new medication that makes it difficult to get up in the morning. She wants to work, but is often coming in late. Lily might be able to take up to 12 weeks of job-protected leave if she is eligible under the FMLA CFRA, even if Lily does not qualify for FMLA CFRA, or if she qualifies for it but needs more than the 12 weeks available under those laws. She may be able to request a leave of absence or an extended leave of absence as a reasonable accommodation for a disability under the ADA FEHA. PTSD is a protected disability under these laws. Finally, Lily may also qualify for leave to obtain services such as counseling under the domestic violence and sexual assault provisions of the California Labor Code. California maintains several programs that provide wage replacement if a survivor needs time off work to care for herself or a family member, or if she is terminated or must leave her job to maintain her or her family's safety. State disability insurance, known as SDI, entitles workers to a maximum of 52 weeks of partial pay at 55% of weekly wages while off work because of an inability to perform their regular or customary work due to physical and mental injuries, illnesses, or other health conditions, including health conditions caused or made worse by domestic violence, sexual assault, or stalking. SDI benefits are administered by the Employment Development Department. Paid family leave entitles workers who participate in the state disability insurance program to a maximum of 6 weeks of partial pay at 55% of weekly wages each year while taking time off from work to care for a child, parent, parent-in-law, spouse, registered domestic partner, sibling, grandparent, or grandchild with a serious health condition, including a condition caused or made worse by domestic violence, sexual assault, or stalking. Paid family leave can also be used while taking time off of work to bond with a new baby, adopted, or foster child in the home. Both SDI and PFL benefits are administered by the Employment Development Department. SB 770 expands the definition of family to include grandparents, grandchildren, parents-in-law, and siblings. The new law went into effect July 1, 2014. Previously, only children, spouses, domestic partners, and parents were considered family. Although workers can now get wage replacement while caring for grandparents, grandchildren, parents-in-law, and siblings, it is important to remember that the job protection available under the FMLA CFRA does not apply to these relatives, only to children, spouses, domestic partners, and parents. Therefore, if someone needs to take leave from work to care for a grandparent, grandchild, parent-in-law, or sibling, they need to be sure that their employer is agreeable to their request to take that time off and will hold their job open for them. California also offers paid sick days and paid safe days for workers. Although these sick and safe days are available statewide as of July 2015, some cities, including San Francisco, have more generous policies. Think about what Martin's rights are while I read his story. Martin's mother was beaten by her boyfriend and is hospitalized. Martin works for a large supermarket. He needs to take time off from work to care for his mother. Martin may be eligible for leave under the FMLA and CFRA if the store has at least 50 employees within a 75 miles radius, as long as he has worked for the supermarket for at least a year and has worked at least 1,250 hours during the year immediately preceding his leave. He may also be eligible for job protection and wage replacement through state or local sick time laws. Martin is probably also eligible for up to 6 weeks of partial wage replacement under the Paid Family Leave Program for the time during which he cares for his mother. In California, good cause includes leaving employment to protect the employee or the employee's children from domestic violence. To establish good cause, a survivor must show that 1. The survivor and/or survivor's children experience an act or threat of domestic violence. 2. The survivor has a restraining order, police report, or other information that identifies the batterer and/or verifies the abuse. And 3. A leave of absence or transfer was not available or would not have resolved the problem. Unemployment insurance benefits provide partial wage replacement to workers who are temporarily unemployed or who work part-time but have very low wages. Although ordinarily workers who quit their jobs are not eligible for unemployment insurance, you may be eligible if you had a compelling reason for quitting your job known as a good cause quit. In California, a domestic violence survivor who quits their job to protect themselves or their family from domestic violence has good cause for leaving that job. In order to demonstrate a good cause quit, you typically must show that you gave your employer an opportunity to fix the problem, for instance, by requesting a leave of absence or safety-related reasonable accommodation. If your employer refuses these requests, or if no work-related changes could have addressed your safety concerns, you should be able to show a good cause quit. It is important that an employer understands that the survivor is leaving her employment for good cause relating to the violence, and that in such situations, the company's reserve account will not be charged for the unemployment insurance claim, as long as the employer notifies the EDD of the circumstances within 10 days of the filing of the claim. If a survivor's employment rights are violated, for instance, if an employer fails to prevent sex-based harassment, refuses to provide an accommodation, or discriminates against an employee based on her status as a survivor, there are various federal and state agencies they should contact in order to preserve their legal claims. Often, an employee is required to file what's called an administrative complaint through one of these agencies before she can file a lawsuit, and there are strict time limits during which she must file her claim. Agencies that address violations of employment are the Equal Employment Opportunity Commission, the Department of Fair Employment and Housing, and the California Division of Labor Standards Enforcement Retaliation Division. Some complaints can be filed with either the state or federal agency, and it may not be clear to whether a survivor's employment rights were violated or which of her rights were violated. In situations where you think there may have been a legal violation, you might want to consider providing a referral to a legal aid service that specializes in employment issues affecting survivors. The Legal Aid Society, Employment Law Center's Project Survive, assists survivors throughout California with employment problems related to the violence. They have a helpline that survivors can call, and someone will talk with them about their specific situation and their legal options. The service is free and confidential. It is important to be aware of these laws when working with survivors. Remember to incorporate questions about the workplace and employment needs into work with the survivor. Many survivors and their employers may be unaware of these protections, so providing information about the available options can be key. Thank you for taking the time to listen to this overview of employment protections for survivors of violence. As you continue to explore Module 12, completing the exercises and activities will provide a deeper understanding of this topic.